Hello?
Hi, may I please speak to Mr. Stevens?
Speaking.
My name is and I'm with the prosecuting attorney's office, and I'm returning your call.
Yes, thanks for returning the call. This is regarding...
Yeah.
We had spoken with... and, wasn't able to get much accomplished. Seems that they have some complaints, or they've been making for a while, some alleging some code violations, and got a number of other agencies involved. But I had called, my question to was about jurisdiction, and I had asked some questions if there was evidence that the code applied to my client, and the best that she was able to do was just keep referring back to the code, saying, let's see what she's got here. When I asked about evidence that the code, that there was jurisdiction and the code applied, she says, yeah, we do because we adopted the code, and she just kept on going in a circle talking about the code being adopted by the board, but not able to give me actual evidence that the code applied.
Well, I think the applicability is based on the geography of the place, and that it's within a certain distance of, which has a legal significance. And it's also within a designated floodplain, I believe. And so, and there's maybe some wetland designation there. I don't know. So there's, basically the proximity to bodies of water and, the floodplain designation. And so you look at the mapping, which is official mapping adopted by the county, and then regulations are applied to it that have to do with those specific triggers. And so, I don't think it's, necessarily easy for a staff person to talk about a legal concept like jurisdiction, and I don't think she's trying to be unhelpful. But, yeah, my understanding is that this activity by Mr. is regulated based on its location, primarily in proximity to the creek and the floodplain. So, Washington State has a Shoreline Management Act and the Growth Management Act, and both of those statutes require local jurisdictions to adopt county code provisions or city code provisions, depending on what kind of jurisdiction you are, that implement the requirements of those state statutes. And county master program has been in place since the 70s, and the growth management regulations that the county is required to adopt have been in place since the 90s. So I don't know how long your client has owned the property. I don't know when he commenced the activity that he's doing, but these are all published codes, and you and I both know as lawyers that once a law is published and it's adopted properly, then, everyone's presumed to know the law. And so, ignorance of the law is no defense. So, Mr. does have to get a permit to do what he is conducting. And because he doesn't have a permit, he needs to stop work and apply for a permit and get the permits in place, and then he can probably, continue at some level. But the reason permits are required is to make sure that if you're going to do any mining activity, that it's done in a manner that is not going to cause undue sedimentation. Primarily, I think, is a lot of what the problem is with these wetland type designations. That you have to put up certain screens, and you have to make sure that you're not dumping the excavated rock or dirt in a place that's damaging to either the riparian area or the floodplain. And, those are the standard things. You just have to be able to demonstrate that you're not conducting the activity in an environmentally unsound manner, contrary to those environmental regulations. So, as far as I'm concerned, if staff people, have measured things, and we have, as I understand it, there was somebody else from at least one other agency, too, that agreed with the county, a state agent and the county agent, both kind of came to the same conclusion. And so, I don't think you have to worry that people are, you've got one, it's not a case where you have one rogue person from the county staff going out there and flipping out. That's not the case. And so as long as I hear that we have agreement for more than one person who's eyeballed it, then I know that there's a reason for what they were doing. So what I would suggest your client do, and, obviously I'm not, going to interfere with whatever legal advice you want to give your guy. I mean, I'm not, wanting to interfere like that. But I think he just needs to stop what he's doing, come into the county and apply for the permits that apply to this type of project. And I can't guarantee any outcome. I don't know the specifics very well, but this is all stuff that's just governed by a permit process. And so, it's not unusual for us to issue a stop work order in this kind of situation at all. And I don't know where your area code is, 602. But I don't know if you're familiar with Washington law. That's not a Washington state area code. And so I'm kind of wondering, maybe this is just something that you haven't had an opportunity to really familiarize yourself with. I don't know anything about other states' laws myself. So, that's generally the gist of what's going on here. And, did that help you? No, I'm actually in Phoenix, and you've given me a lot to respond to, so I'll do my best to get to everything. You kind of marginalize the idea of the agent can't speak about certain things. That if she's going to insist she has jurisdiction over somebody and it's affecting another person and using aggression against them, then it is. It's proper for them to know what they're talking about. Someone, if they're insisting they have jurisdiction or aggressing against somebody, should be able to articulate the facts on which they rely on to support that opinion. And basically, let me give an analogy to kind of, because you're saying my client's physical location means some code applies to him. Now, that would be the same as saying a Catholic bishop sets up a parish and that everyone in that area is now a member of this church and has to pay a tithe because that's what the rules say. This comes down to an issue of evidence. And you're talking about the codes, but what evidence do you have that the codes actually apply to my client is the fundamental issue that we're trying to address here. Because the jurisdiction is based on the codes, and you're applying these codes. So what evidence, if any, do you have that the codes actually apply to my client? Well, just, that's the way legislation is adopted by every state and by every local jurisdiction, in that, this is no different than a zoning code. It just happens to cover environmental issues. So if you live in a part of your city where the city code, zoning code, has stated that only one-story buildings are permitted to be built, and you go into the city and apply for a permit to build a 3-story building, your permit's going to be denied because the city has jurisdiction over that structure. And they will give you a permit for a 1-story building, and you will get denied your permit request for a 3-story building, and then you're entitled to appeal that. Well, but that's Ma'am, that's not answering the question. It's exactly answering the question. It's an analogy. No, but okay. I'm asking. I'm sorry, but this is basic law school stuff. This is law school stuff. Ma'am, there's no reason for you to get upset with me. I've said nothing to warrant you all of a sudden on a dime like that just start raising your voice and getting mad. I asked you for facts. Let me finish. I asked you for the facts that the code applies. Telling me it was adopted by every state doesn't give me evidence, that empirical proof that it applies to my client. You're giving me a political platitude with no substance behind. I'm asking for facts. Okay, no, I have told you that the physical layout of your client's property, given that it is near, that it is in a floodplain, that there is a riparian area, like I said, and a wetland area apparently on the property. Those geographical type factors trigger applicability of regulations that must be complied with when you are in that kind of a geographical setup.
What makes you think that that's true? What are you basing that on?
The Shoreline Master Program of County, the Shoreline Management Act of the State of Washington, the Growth Management Act of the State of Washington, and the environmental regulations of county.
Okay, so when let me finish. Now, when you go back to the code, that's circular. You're trying to say that the code applies because the code
we adopted
said so.
it.
Okay, I understand that. I understand that you say you adopted. I get that. I'm not debating that. What I'm talking about, or I'm not challenging that. What I'm talking about is, I'm asking you for the facts the code is applicable, and you keep going back to the code itself.
No, I'm going back to the geography.
But that's based on the code. That's based on. But that goes right back to the code. I asked you why you think that's true, and you went back to the code. You're saying that because the code says that. I told you that
jurisdiction applies based on the geographical location and features on this property.
How does the code become applicable because of geography?
Well, how is it that the city of Phoenix doesn't have the right to adopt traffic regulations?
The question is, how does the geography create the applicability?
This is what I recommend. I recommend that your client take advantage of the appellate process that's indicated on the stop work order. And if your client wants to appeal the order, we have a procedure here, and he can go have a hearing in front of the hearing examiner, and you guys can talk to the hearing examiner about jurisdiction.
Well,
and it's okay that you have these questions. I'm not trying to argue with you.
You don't have to. You just have to answer the question.
I have answered your question.
No. Why? Tell me exactly why the code is applicable because of geography.
Well, it just is.
Whoa, let me write that down.
Well, can I ask, what is your first name?
My name is Marc.
I'm going to have to go ahead and sort
Marc
of disagree
Stevens,
with you
and do you spell Stevens with a PH or a V?
With a V. It just is.
Stevens. Yeah. And are you a member of the Arizona State Bar Association?
No, I have not presented myself as a member of a labor union, so no, I'm not. But I think
so are you a member of any any lawyer bar association?
It's not relevant. You just said it's applicable because it just is.
Well, is Mr. your client in our? Because see, I'm trying to find out if the if you're basically a lawyer that's going to represent your client in the state of Washington, and I just want to know for the sake of lawyer responsibility. So.
No,
you're not a member of a bar.
No, I belong to no labor unions. No, not in Washington. Not anywhere. And I think it's significant that you did finally admit that it just is. That's really not a basis of
what is your
evidence.
Job title?
What's my job title?
Yeah, I mean, what are you? I mean, do you? I just was wondering, have you gone to law school?
How is that relevant to the issue where you're saying the basis of your jurisdiction is it just is? How is that even remotely relevant to that?
That's not what I said.
Tell me exactly why the code is applicable because of geography.
Well, it just is.
Whoa, let me write that down.
Okay, Mr. Stevens, what I'm saying is we're talking about legal issues and theories of law, and it would help for me to know if you were a lawyer so that, I could understand, what it is that might help the discussion, further the discussion. But what I understand is you're not a lawyer, and
no. I never pretended to be, and I never led you to believe that I was. It was one of the points.
Well, I'm sorry, I did get a message from someone that said that they thought that you were representing yourself that way. But that's okay if you're not. I'm glad you clarified that. But you somehow, Mr. is your client?
Yes, I assist people in that are being attacked by bureaucracies. And, and we're not necessarily.
What's the name of your business?
It's just me, Marc Stevens.
Oh, okay. Well, basically what I think your client is entitled to is the remedies spelled out at the end of the stop work order. If he wants to request an appeal, he can.
Okay.
And if he wants to get a lawyer to help him with that process, there are local lawyers here in county that deal with land use stuff. And, so he's not without resources here locally. I'd be happy to talk to an attorney that does represent Mr. And that has some familiarity with the environmental regulations that we're talking about.
Why is that necessary when you can't establish jurisdiction beyond it just is?
Well, okay, but see, this is the thing: is it's a legal conclusion as to whether or not jurisdiction exists. And the hearing examiner, I'm confident that the hearing examiner here and that the appellate process here would establish that yes, the county does have jurisdiction to regulate this.
Because it just is. It just is.
No, I've told you, it's based on geography and it's based on the legislative process.
And the connection just is. You've given me no evidence whatsoever, and so you're confident at this point there's evidence of jurisdiction?
Mr. Stevens, I think we've been over this territory in this conversation already.
Yeah.
Okay.
I think I'm. Let's see. Your boss would be. Is your husband still your boss? Come on. I need to speak to someone on the chain of command.
My supervisor is not my husband.
Okay. But your husband is the county attorney?
Yes.
Okay. Well, then I'll speak to your supervisor then before going to over his head. What was your supervisor's name? I
think he's in court today.
Okay.
The thing that you need to remember though is that there isn't going to be a resolution by just having phone calls, and your client needs to make a decision here and not just simply make phone calls. So he needs to make a decision.
Well, we've got some evidence now. We've got some statements from yourself that it just is. And if you are going to allow, now that you know that there's really no evidence beyond it just is, if you continue allowing the aggression against my client, that would be misconduct on your part. To knowingly allow the aggression against my client when you have no evidence the code applies. It just is not a foundation of evidence. It isn't. Okay.
Well, Mr. Stevens, the people involved in doing the code enforcement are not overly, enthusiastic about doing it. They are doing what they feel is required of them as their job, and they're not being aggressive. So I'm going to